very much. I'm delighted to have the opportunity of speaking on this motion regarding the report of the Standing Order Committee, Select Committee, or Standing Order 103 Select Committee, on the proposal for a Council Directive on a common consolidated corporate tax base. I listened to Deputy Tobin there speaking about the Department of Finance. I think he's not quite correct in what he said there. The Department of Finance, when we met them in the committee, said that it was their preliminary advice that this may well not be in breach of subsidiarity, but they emphasised that. So what their final position is, we don't know at this point in time. And in relation to the matters about the Labour Party and Fine Gael and Deputy Hayes talking about engaging in relation to the tax issue and the bailout, essentially that's what we are doing. We have always said we would do it. We're in the process of doing it. We don't throw out the baby with the bathwater. We are engaged with Europe. We are members of Europe, and there's not much sense in being, as you are, in favour of this motion, and on the other hand you're not prepared to argue the case and put it forward in a coherent and a rational fashion rather than just attacking the parties on the other side. So we need a bit more cohesion and a bit more rationality in arguing it on Ireland's behalf. The principle of subsidiarity is, in my mind, it is the most fundamental principle governing the entire operation of the European Union. And as Article 5.3 of the Treaty of the European Union states, quote, "The Union shall act only if and insofar as the objectives of the proposed action cannot be sufficiently achieved by the Member States." Now, national parliaments have been given for the first time under the Lisbon Treaty a power to determine what constitutes the principle of subsidiarity. It's not a legal power. It is a legal power. It's not a legal decision. It's a political decision. It's an Oireachtas decision. It is the decision of all the parliaments in the 27 member states. We decide, not the Commission, not the Council. We are the ones that make up our minds. And if enough of us make up our minds that this infringes on the principle of subsidiarity, then the matter has to be rectified by the Commission and the Council. And that's the power that we have. We are the watchdogs, for the first time ever. We are the watchdogs of policy making in the European Union. We must engage, Deputy. We must engage, and we must engage rationally with a rational, reasonable opinion. And that's what we're doing here. What Deputy Flanagan has presented to us are the arguments that the committee has put forward. These are the rational arguments why we're saying this infringes the principle of subsidiarity. And it is the first time ever that it has been done. My only regret is that we weren't able to do it at an earlier stage because of the election and because of the unfortunate situation where the Senate hasn't been convened. And therefore we would have two votes rather than having the one vote that we have at the present time. That, unfortunately, is the situation. I always express some concerns about the fact that the 8-week period was just that bit too short for each Parliament to make its own determination in its committee, then go to the plenary and then campaign with other member states. But unfortunately, that is the situation where we're in, so we must maximise it insofar as we can. So now all legislative proposals emanating from the European Commission must satisfy that principle of subsidiarity and must be subject to that subsidiarity test. Now, the original purpose of the CCTB proposals is to facilitate cross-border trade by having a centralised mechanism for tax assessment in the EU countries in which the traded goods are sold, and a centralised formula for the allocation of that tax based on the sales, the payroll, number of employees and assets of companies. Clearly, allocating taxes on this basis would be a significant change from the status quo. Theoretically, the proposal would redistribute the tax base between member states, while the member states themselves would continue to set their own corporate tax rates. However, if the impact of the proposal on member states altered their revenue stream, clearly tax rate adjustments would have to be made by the member states, which could amount to an indirect interference in member states in their setting of their own tax rates, and this would be, in my mind, a clear breach of the principle of subsidiarity. But what is signally missing from the proposals is any evidence that the CCCTB will actually achieve the objective intended.
2 minutes left, Deputy.
namely to facilitate cross-border trade between the Member States. Big businesses and multinationals do not need assistance to conduct business in many countries. They are adept at doing so. It's in their DNA. That is the very nature of multinationals. It is the small and medium businesses that require assistance in conducting cross-border trade efficiently and at a reasonable cost. But it is difficult to see the value of a harmonised tax assessment mechanism based on the tax returns from the country where the produce is sold as having any benefit for the promotion of cross-border trade. It is not clear how this can be a solution. Indeed, it may very well be counterproductive. It may, in fact, impede the countries of origin where the business is based and where the goods are produced from setting their own corporate tax levels as they consider appropriate, which of course would need to suit their particular business model. And I would say that small and medium enterprises do need assistance in accessing a variety of markets in a number of countries, but it is likely that they would be best served by a one-stop shop of financial and regulatory assistance and of business direction by any form of tax harmonisation. So far more detailed information is required before all the implications of a cross-border proposal of this nature can be adequately assessed as to what benefits it might have and whether the EU-wide action is necessary to achieve the objectives of the proposal. Indeed, research proposals from Ernst & Young that mentioned here earlier have shown that Ireland would be among a group of 6 countries that would benefit least, while France and Germany would be amongst the larger countries that would benefit most. And interesting enough, it is France and Germany that are the main protagonists of the CCCTB. So could I say in conclusion that there are very serious questions to be asked in relation to this proposal in terms of subsidiarity. Much more detail is required, a much wider argument, much more information in relation to the benefits to be obtained, and finally, much more information is required as to whether or not what is supposed to be achieved would be achieved by the mechanism proposed.
Thank you, Deputy.